Convicted killer and former Paralympic star Oscar Pistorius is eligible for release on parole, and his murdered girlfriend's parents say they are willing to meet with him as part of that process. Pistorius became eligible for parole after the Supreme Court of Appeal corrected its ruling on his sentence for a second time, antedating the 13 years and 5-month jail term it had imposed on him to the 21st of October 2014, the day he was first sentenced for culpable homicide by Judge Thokozile Masipa. The appeal court had previously amended that sentence after it emerged that its judgment failed to take into account the 506 days that Pistorius had already served for Steenkamp's murder. While the Department of Correctional Services had previously maintained that Pistorius would only become eligible for parole in March 2023, when it calculated that he had served half of his sentence, the appeal court's ruling effectively pushed that date forward by 10 months, to July this year. Attorney Tanya Kern, who represents Barry and June Steenkamp, told News 24 that they had been taken aback when they were approached by Correctional Services officials in regard to Pistorius's parole hearing, which had been scheduled to take place on the 27th and the 29th of October, because they believed he would only be up for parole in 2 years' time. After preparing themselves to again open the deep wounds linked to their 30-year-old daughter's Valentine's Day murder, Kern said the Steenkamps were shocked when Correctional Services staff cancelled their appointment with the couple at the last minute. They have always maintained that the law must take its course, and that remains their position. If Pistorius is eligible for parole, then that process needs to be conducted in the correct manner, she said. Asked if the Steenkamps were prepared to engage in a so-called victim-offender dialogue with Pistorius, a process that precedes a parole hearing, Kern responded, "Yes, they are." She did not want to disclose what the Steenkamps were hoping would come out of this process, or provide any details on what their attitude towards Pistorius being granted parole may be. "There really are no winners here, and this is an emotional time for everyone," she said, adding, "No matter what happens here, Barry and June won't get their daughter back. They would ask for privacy as they participate in this parole process." Correctional Services spokesperson Singabako Nzumalo confirmed the department had approached the Steenkamps in relation to a possible victim-offender dialogue with Pistorius, a process that he said was an important precursor to a parole hearing. Prior to an offender being considered for parole placement, he or she must participate in programs aimed at preparing them for a crime-free life beyond incarceration, he said. Such programs must include, amongst others, restorative justice, wherein offenders are able to acknowledge and take responsibility for their actions. It is critical for inmates to comprehend the harm they have caused their victims, their communities, and the process has to create an opportunity for parties to reconcile or an apology. Nzumalo declined to comment on the seemingly insensitive way the department had arranged to meet with the Steenkamps, and then abruptly cancelled that meeting. He did, however, explain that Pistorius's parole process had been delayed by logistical difficulties. As offender Pistorius is incarcerated in Gauteng and the Steenkamp family residing in another province, the Department of Correctional Services has to work out logistical arrangements that will be convenient to the victims of crime, he said. He added that this had necessitated a deferral of Pistorius's parole hearing, as we are finalizing the modalities, which will ensure that all relevant parties are well prepared and ready to participate in a conducive environment. Nzumalo also stressed that the department's specialists, social workers, psychologists and spiritual caregivers would assist in preparing the Steenkamps for their face-to-face interaction with Pistorius, as this can be a sensitive, emotional and inconsolable engagement. Hence the need to prepare all participants, including the offender, and an aftercare debriefing has to be made available, as this can never be a once-off moment. All participants must be provided with complete information as to the purpose of the process, their rights within the process, and the possible outcomes of the process. Pistorius's attorney Julian Knight has told News 24 that he was very willing to meet with the Steenkamps and had been wanting to do so for a very long time. He added, "But he is also aware that there are profound sensitivities involved. He respects that, as such, the Department of Correctional Services is best placed to facilitate engagements between himself and the Steenkamps. During Pistorius's parole hearing, the parole board will consider a number of reports prepared as part of his so-called offender profile. These include reports prepared by a social worker and psychologist, a vocational report, and a report by his prison unit manager. Finally, the parole board needs to evaluate a case management committee report which seeks to monitor a prospective parolee's rehabilitation process and makes a recommendation on whether he or she should be released on parole. It is only when these reports are completed and the victims of the offender's crime have been approached and potentially consulted that an inmate's parole application can be properly considered. Pistorius went on trial for murder after he shot and killed Steenkamp in the early hours of Valentine's Day 2013, after opening fire on her while she was standing behind his closed bedroom toilet door. He maintained that he believed that she was an intruder, while the state contended that he had killed her during an altercation. Judge Thokozile Masipa believed Pistorius's account of the shooting and convicted him of culpable homicide, a finding that was overturned by the Supreme Court of Appeal. The appeal court found that, even if Pistorius had believed that he was shooting at an intruder when he fired multiple shots into his bathroom door, he must have reasonably foreseen that whoever was behind that door would die. As such, it said, he was guilty of murder under the principle of dolus eventualis. The case was referred back to Masipa for a new sentence. The appeal court, in a ruling written by Judge Willie Cerruti, later found that the 6-year murder sentence Masipa subsequently handed down to Pistorius was shockingly lenient, and found that there were no substantial and compelling reasons not to give him the minimum prescribed sentence for murder, 15 years. The appeal court did, however, deduct the 12-month prison sentence and 7 months of correctional supervision he had already served for culpable homicide from his sentence. Thanks for watching this video. See you next time.